Good morning. We'll wait till 11:30 for the actual start, but as you'll see, we've got a clock in the upper left hand, at least on my screen. And as you know, that's your entire time, including your rebuttal time. The yellow light will come on. If it's not readily obvious to you, I may remind you to let you know that you're into your rebuttal time. And with that, now that it is 11:30, welcome to a session of oral arguments in front of the 5th District Court of Appeal. I'm Judge Jim Edwards. I will be presiding. I'm joined by Judge Scott Makar and Judge Joe Boatwright on the panel. We have one case on this video conference oral argument, and that's Amber Bratch versus Joseph Bratch. And I invite y'all to correct the pronunciation if I got it wrong. It's case number 22-2029. If you have a phone or other noisemaker, please put it on a vibrate or silent. Don't turn it all the way off, because if we lose you, that's how we're going to get you back. So as soon as counsel for the appellant is ready, we can proceed.
Good morning. My name is Elizabeth Harris, and I represent Amber Bratch. If I could, I've reserved 5 minutes for rebuttal. I'd like to center my presentation on 3 points regarding the relocation issue that we presented in our briefs. First, the three that I'd like to center on is the trial courts putting relocation on the table at the time of trial in May of 21, the interpretation and application of the relocation statute, and finally the trial judges ordering, under the authority of the relocation statute, ordering the mother to return to Florida. Now, in a little recitation of the facts might be helpful, in the sense that they just put a time frame on things. The petition for dissolution is filed in October 19th of 2018. In May, and I believe it's February of 2019, we have 2 factual determinations by the trial judge that relocation is not an issue. The mother has moved prior to the filing of the dissolution of marriage. So that occurs in 2019. In 2020, in January 2020, and I believe this is a significant fact, the parties enter into a stipulation for appointment of a social investigator. That social investigation is detailed what the investigators to look at. Relocation is not mentioned there at all. We know from the deposition in the record that had the investigator been tasked with examining the relocation factors, it would have been in the order. He testifies, or in his deposition, that he viewed this as a non-relocation case. Relocation was not in the stipulated order. And so he proceeded forward as though it's not a relocation case. That deposition occurs in 2021. 2021, that's right, in 2021. That deposition occurs then. So we have the morning of trial comes, and the judge decides that relocation is now back on the table, and the court, the briefs discuss the authority of the court to reconsider, and that's not the contention that we have, is that the court could not have reconsidered. However, our position is that the court would have to have reconsidered, one, within the scope of its judicial discretion, and secondly, there's no invocation of the court's authority to reconsider. There's nothing presented. What we have at that time of trial is a factual determination that's never challenged. Also, to backtrack just a bit, after the, I believe it's the May 2019 order where the court finds relocation does not apply, there is a motion for reconsideration filed, but it doesn't challenge that finding. It's on another aspect of the order. So we fast forward to 2021, and the court says, well, if a party relocates, I don't have the authority to allow the relocation. But the court's coming from the court's not factoring in that there's a prior factual determination. So his finding at that point, any evidence related to relocation simply would have been irrelevant, because relocation's not on the table. There's no pleading to relocation. The introduction of that evidence would have been irrelevant. So,
Ms. Harris, is the trial court able to take that up on their own without a pleading from the other party?
I believe that the answer to your question, I think, would be couched in terms of the discretion of the court, because while the court has that, may reconsider and may do it sua sponte. And here, the principal part is it's the morning of trial, so there's no notice to anyone. And I would suggest to you the continuance does not solve the problem because of the social investigation. You can't fix the social investigation that the other side agreed to. Remember, it's a stipulated order. They agree what the task of the social investigator is going to be. The two parties agree, and it doesn't say look at relocation. And it becomes critical because throughout the remainder of the proceedings, there's an effort to discount the social investigation. And actually, there's requests on at least 2 occasions to strike it because it doesn't consider relocation. So while the answer to your question is, I believe the court can sua sponte reconsider it. The larger question in my estimation is, can the court do it with no notice on the morning of trial, require the other side to amend their pleadings that effectively undermines the social investigation? And also the timing here is critical, because we have almost about 2.5 years to the trial date. We have about 14 months from the time the dissolution is filed to the stipulated order on relocation. We got about a year from the time the court makes the first finding that there's no relocation involved. Then we have COVID that comes along. So we've got this significant delay before we even get to May of 21. That's also an important factor here, is they repeatedly argue that this report is stale, but it's stale in part because we have the COVID delays, but it becomes a point of contention in November of 21 because now it's stale and it doesn't consider relocation. And I think that's an abuse of the court's discretion to have reconsidered it in that context with no evidence to have challenged its original finding. I think the problem with the relocation gets further compounded because the court misinterprets what the statute requires. The court says in its final in the final judgment, I'm not very good at pronouncing names, so I won't try to pronounce the hard part of the name. I'll call it the Carter case. In the order, the judge says, equates what the statute says to legal domicile. And the important part that the court quotes from is, the court says a change of residence is accomplished and becomes effective when there's a good faith intention to establish it, coupled with the actual physical move to the new residence. This is so because legal residence consists of concurrence of both fact and omission. So that the court says here, where the statute doesn't say legal residence or legal domicile, it says principal place of residence. And there's case law coming out of this court that says residence, you can have multiple residences. You can have temporary residence, you can have multiple residents, and what it amounts to is a question of fact. It's actual presence. The intent comes in when you're trying to establish legal residence. So the court here makes a determination that the statute requires something, if not exactly, a legal residence or a legal domicile. And that's not this legislature, that's not the language the legislation used. The legislature plainly says relocation involves a change in location of principal place of residence. Had the legislature wanted it to be you're in a legal residence or a legal domicile, it could very easily have said that, but it specifically references residence. And the case law out of this court says residence equals actual presence. It does not talk about, and just to expand a little bit on the legal domicile or legal residence, that's talking about something that is a fixed or permanent home. And it is clear that the case law talks about there has to be an intent there with a legal domicile to form a fixed permanent home with the intent. That's vastly different than what residence is defined both under the statutes when we're talking about residence for 6 months residence for filing a petition for dissolution in Florida. The case law has looked at that portion of the statute, and I think it's 61021. I think that's the statute number, but they've talked about how that's actual presence in Florida. They don't equate it to a legal domicile. So I think in doing what the court did, the court has taken the language of this or added to what the legislature expressly provided in the statute and changed that. I would also suggest to you that the facts simply don't support that she moved or she changed her intent. If we're going to talk about the intent, I think that the findings that the court makes in its final judgment are not supported by the record. If we're going to go that route, and I would suggest that this court doesn't need to do that, this court can say, not only did the court abuse its discretion in permitting the resident or the relocation to become an issue in light of the passage of time, it's the morning of trial. And most importantly, that social investigation, there's simply no way to correct that, because I also want to point out that in the deposition as well at trial, the social investigator says, I couldn't have come back and worked on this family again. I couldn't have done that. So these parties who paid $8,000 for a social investigation now have an issue, a significant issue placed on the morning of trial with respect to relocation that they have not done. And now the other side takes advantage of that and moves to strike it. And in fact, the court really does not consider much of what's in that social investigation, and to the detriment of the mother here. Finally, with respect to the court requesting that the mother relocate to Florida, it's clear in the final judgment that the court says that time sharing is dependent on the mother being physically present in Florida. Repeatedly, the court says, I believe if it's paragraph 51 of the final judgment, that the mother is ordered to relocate her residence to Florida. The relocation statute talks about what a trial court can do in the event a child is not returned, but the statute does not authorize a trial court to require a mother or father to return to Florida. And it's evident from the statute, from the final judgment, that the trial judge contemplates the fact that the mother, as a result of that order, will be unemployed. And I think that sort of goes without saying. We all would understand that if she's ordered to leave Maryland, she has to lose her job in Maryland. And that's exactly what the court contemplates in there.
Counsel, if I could ask a quick question, it goes back one step on your argument. The principal residence issue, I guess your position is that your client established the principal residence in Maryland before the filing of the petition. So what facts would support that, and why was it an abuse of discretion for the trial court to hold otherwise?
Well, I believe that, and perhaps I've misunderstood your question. I believe in finding that the mother moved after the filing of the dissolution of marriage. I believe that's not supported by the evidence. In the positions, where I would rely on that is we have evidence that she takes everything. She has a packed car. He himself says, I didn't think she was coming back. She probably wasn't coming back. She develops a safety plan with the counselor to exit Florida. She has a credit card that she takes, that she's given to a neighbor that she picks up before she goes. The court makes much of what appears to be some equivocation in the exchange of text messages on October 18th, but I think it's clear from that text message, coupled with the mother's testimony, that she says, once he says, we are going to live in the house together and I'm going to put cameras in the house, that's what we're going to do. And she says, that seals the deal. I'm not coming back. That's the October 18th. The dissolution is filed on the 19th. If where it becomes jumbled up is where the trial court now is saying there had to be an intent when she left Florida. And I would say that's not what the statute requires, an intent when she left Florida. She doesn't have to have an intent. In my opinion, she doesn't have an intent at all. And because that confuses the change in principal residence and makes it a legal domicile. And he relies on those cases. We know that's what the trial judge is doing because he relies on that case. Once she testified, that sealed the deal. I think those were her exact words. The proposal that cameras would be in the house and they would share the house. She says, I'm done. That seals the deal. I'm not going back there. The dissolution is filed the next day. That's where I believe the evidence supports, not the trial court's finding that she did not make the intent until after October 20th. I think there's no evidence to support that she decided that after October 20th, as the trial court found in the final judgment.
Under the circumstances, what remedy do you think you're entitled to for your client?
I believe that the relocation it was abuse of discretion for the court to put relocation on the table. In that instance, I think we have to have a remand for determination of a long distance time sharing, which was what was presented or asked from the onset, a determination of a long distance time sharing plan.
All right, and you're into your rebuttal time if you want to save the rest of that.
I do. Thank you, sir.
All right, counsel for the father.
May it please the court, Erin Newell with Florida Appeals. We represent the father. All of the court's rulings that are challenged in this appeal are subject to the court's discretion. The court did not abuse its discretion in denying the mother's petition for relocation, nor did the court abuse its discretion in allocating the mother's share of the mortgage payments and other house expenses to the father as part of equitable distribution, nor did the court abuse its discretion in denying the mother's application for attorney's fees under 6116. The mother only focuses on the relocation issue, so I will tailor my response to that in front of this court. Judge Boatwright, I think, hit the nail on the head when he asked the question, can the court take up relocation on its own? And Ms. Harris had to concede that, yes, the court does have inherent discretion. It may sua sponte reconsider any of its interlocutory rulings at any time. The argument that the nature in which the court readdressed this issue somehow exceeded the scope of its discretion is incorrect. The court was very conscientious and actually did grant that motion for continuance. The timeline that Ms. Harris refers to points out that that continuance was granted in May of 2021, and trial did not commence until November, the end of November, nearly December. So there was a 6-month period of time. And during that time, the amended petition was in fact filed. So it was, the court did not abuse its discretion in reconsidering its interlocutory ruling regarding the applicability of the relocation statute. In terms of the court's interpretation and application of the statute, the question of the relocating party's intent is central to the relocation statute. Before the relocation statute was rehauled in 2009, the relocating party was actually required to file a notice of intent to relocate. Now it's called a petition for relocation, but I don't think anyone can question that the legislature had the party's intent in the center of its mind when it was writing section 6113.001C, which specifically details all of the requirements that the petitioning party must state about their intended location, their intended address, all of these things that they are meant to form before they actually move. And that's the purpose of the relocation statute. When a party desires to relocate after they are subject to the court's, after there's been a petition that's been filed for time sharing or parental responsibility, any of those things, the relocating party has to ask the court's permission and has to make a case if the other party doesn't agree for why the relocation should be granted. And it is the relocating party's burden of proof to make that case. In terms of the court's reliance on the Carter case, the court did not err in looking at the reasoning of the Carter case. The court does not actually state in its order legal domicile. It is talking about the primary residence. In paragraph 30 of the final judgment at page 3562 is very clear that what it was looking for was intention plus actual physical move. And that is on all fours with the plain language of 61-13001. Because the language of the statute is the primary indication of the legislature's intent, the court got it right in this case by looking at intent of the party. Moving on to, Judge Makar had asked about, what about the court's conclusion about the mother's relocation after the petition? How does the court abuse its discretion in that regard? The court sets forth very detailed, for about 2 pages, of all of the fact findings that it relied on in determining that the mother had not relocated until after the petition was filed. Those fact findings are supported by competent substantial evidence. Ms. Harris has not argued that any single one of those multiple fact findings were not supported by the record. They are, in fact, supported by the record. They're supported by the testimony of the party's neighbor at the time. They're supported by the testimony of the father, the text messages that were going back and forth, and most importantly, and this is something that the mother has relied on heavily today, the social investigator. Dr. Goodwin's testimony actually states that based on the data that he had collected, a finding that the mother intended to relocate before the petition was filed would be inconsistent with that data. Dr. Goodwin's opinion on the relocation issue when asked to give one was that the mother did not intend to relocate until after that petition had been filed. All of these bases are supported evidentiary facts that the court properly considered, and it did not abuse its discretion in determining that the former wife did not relocate until after the petition was filed. Even if we were to accept this position that the court erred in considering intent, and even if the court's findings were not supported by the record evidence, there's still another basis for this court to affirm that finding, and that's the plain language of the statute. Now the statute defines residence as having been consecutive for 60 days and not for the purpose of vacation. So we have the mother's own testimony during trial. It's at page 72 of the transcript, where she admits that she was there for vacation. She had only been there 7 days. So a relocation cannot take place per the plain language of the statute until the party has actually been in the new place for 60 consecutive days when they're not.
Was that
Yes, sir.
the version of the statute in effect at the time of the trial?
Yes, that is correct, Your Honor. Yeah, and that's the definition of relocation under the current version of the statute.
What about
So-
when the judge made the original ruling? Was that statute in place?
I believe so. The statute was overhauled in 2009, and I'm going back, 2018 petition for dissolution. As per the facts, February 2019 was the original finding that the interlocutory finding that the relocation statute was not at issue. And then the court reconsidered its interlocutory ruling and determined that it was going to consider whether relocation applied in that May of 2021 hearing, as Ms. Harris points out. But again, 6 months later, after the filing of an amended petition which put relocation at issue, the court went ahead and looked at all of these facts and determined that based on the testimony and all of the facts before it, the wife did not relocate until after that petition was filed. For those reasons, it did not abuse its discretion. In the last issue that has been raised today is that in ordering the mother to return to Florida, the court essentially abused its discretion. The court did not abuse its discretion because the court was following the language of the statute. We have to go back again and look at the actual language of the statute. And the way relocation is now defined is it's defined in terms of the parent's location. When we look at paragraph 51, it's very clear that the court is tracking the language of the statute. And I'm going to quote directly. When the respondent, it's about halfway through paragraph 51, the respondent is ordered to relocate her residence to Brevard County, Florida, no later than 30 days after the final judgment. That sentence, standing alone, is simply tracking the language of the relocation statute and the definition of residence. It's now tied to the parent's primary residence rather than the location of the child as it had previously been done. The remainder of this paragraph is very clear in the context of this entire paragraph that the court is directing the mother to bring the child back to Florida. The child shall begin to reside in Brevard County, Florida. The child must be brought back. And if you look at the final sentence, the judgment does contemplate that if the respondent does not relocate, then the child must be located in Florida. So it's very clear when you're not looking at one sentence in a vacuum, when you're looking at the entire context of that paragraph, that what the court is truly attempting to do and ordering the parties to do is to have that child located in Florida. The reason that the court has ruled for the child to be located in Florida is very clearly that it found it in the best interest of the child for that time sharing to take place and for the child to be located in Florida. The court spends nearly 10 pages of the order going through meticulously each and every one of the relocation factors and making fact findings regarding those factors. The court is explicit regarding the evidence that it was expecting to see from the mother that was not offered, and all of its findings are supported by competent substantial evidence. For those reasons, the court did not abuse its discretion in denying the petition to relocate, and the court has properly applied the statute. One thing we don't see in this appeal is any sort of constitutional challenge about the statute itself. What the wife or the mother really takes issue with is the nature of the statute. The statute talks about the primary residence of the parent. That's what the mother takes issue with. She did not challenge the constitutionality of the statute in the trial court. She hasn't challenged the constitutionality of the statute here. The final judgment does not unconstitutionally infringe on the mother's rights because there is competent substantial evidence supporting the court's fact findings.
Counsel, if I could ask a quick
I
question.
see that.
On the attorney's fees
Yes.
issue, the judge's order, paragraph 92, I don't see a page, 3544 is the page number, but the trial judge says, the court notes that this litigation persisted almost entirely due to the respondent's decision to relocate. I believe based upon that finding, at least in substantial part, basically said, each going to bear your own attorney's fees. Is that accurate? It was, I mean, what percentage of the $170-some thousand of attorney's fees that the parties have spent at the trial level was due to the relocation issue?
I think the best indication of that answer, and there really isn't a clear place that I can look in the record to point you to, unfortunately, but the court does actually say what each of the parties had spent in litigation in its order. So paragraph 84 and paragraph 85 indicate that the father had spent half, essentially, not completely half, but nearly half of what the mother had spent on attorney's fees in litigation. So the lion's share of attorney's fees was being expended by the mother in this case. I think that's indicative of the trial court's ruling. I think it's also indicative the fact that the mother had been denying that she had, had not relocated yet. And she took this position for 6 months between the time that she was ordered to file the petition and when trial actually happened. She was challenging the idea that the relocation statute could apply. So that certainly drew out litigation and made the litigation persist unnecessarily, whereas she could have, essentially admitted that she hadn't relocated under the current iteration of the statute. And again, I point the court to the definition of relocation. It's very clear, notwithstanding the whole intent issue, that the former wife had not been in Maryland for 60 consecutive days, and that she was in fact there for vacation. So,
if I can interrupt on that point on the 60 days, was that discussed in the trial court's order, or was that litigated by the parties, the 60-day issue?
yes, I believe that the court does in fact note that. I'm going to double check right now to let you know exactly. It's absolutely noted that she was there for vacation. I'm confident in that. And the amount of days that she was there, being 7 days, was also noted. I'm going to point you to paragraph 28 of the order, which is page 3562. The court notes that the statute provides the change of residence will not be found if the change is only temporary for the purposes of vacation. And it does find that she was there for the purposes of vacation.
Okay.
So yes,
But it doesn't mention the 60 days.
I do not believe that it mentions the 60 days, Your Honor. That's correct.
Okay. So the trial judge is basically saying, I'm viewing this as an exception under the statute, the vacation exception. It's not, although I'm not sure he actually comes right out and says that.
Correct. He notes this. I think the main thrust of the court's findings was based on the intent, as it found based on the evidence presented that the wife did not form an intention to actually relocate to Maryland until after. And again, that testimony, a great amount of it came from Dr. Goodwin, his conclusion as an expert that the data didn't support a finding that she relocated prior to the petition being filed. So, in terms of the attorney's fees, I did want to just revisit that because I feel like I may not have fully answered your question. I do want to note this case does differ from the case that the mother relies on. She relies on a Kari, which is a 5th DCA case from 2013. Essentially, the mother is saying that the former wife had to pay her parents back. And that's what they really rest their hats on. And they contend that the evidence was uncontroverted. What the court found is that the evidence was uncorroborated. The trial court is in the best.
Was there anything to
place.
rebut? Was there anything to rebut I guess her mother testified that she had loaned her money, correct? Was there anything that was presented that rebutted that?
Presented by the father, not necessarily, although the father did on cross-examination get some information from the mother's mother, in which she admitted that all of the debt that was accumulated was in the form of credit cards, and the credit cards were not in the mother's name, they were in the parents' name. So in terms of the nature of the debt that had been allegedly, incurred, that the mother contended she had to pay back, that debt was in the form of credit card debt. So that, while necessarily doesn't controvert it, the fact of the matter is it was uncorroborated with any documentary evidence. And the trial court, being in the best place to assess the credibility of the witnesses that were testifying, it found that that was important in its order. It specifically says in the attorney's fees and costs section of its order that there was no corroborating evidence other than her mother's testimony of a specific obligation to repay that money. That, in light of the entire equities of the case that the trial court clearly considered per its final judgment, should require this court to affirm, because there is no abuse of discretion in the trial court's findings. Finally, with the last few minutes I have, I would like to touch upon the court's allocation of payments to the father. The mother's half of those marital home expenses, the mortgage, were credited to the father. The mother relied on a 5th DCA case, Cortez, which reversed an allocation for 3 very specific reasons, and all of them just simply do not apply here. The first reason was that the husband didn't request a credit in Cortez. Here, the husband clearly pled entitlement to a credit. There was no point in time where the husband conceded or withdrew or stipulated to paying those expenses without receiving a credit. So he maintained that prayer for a credit for that relief. Secondly, in Cortez, the husband was generally responsible for paying the mortgage by virtue of being, quote, the primary breadwinner. While the mother certainly tried to portray the father as the primary breadwinner in this relationship, it was the mother who was the primary mortgage holder in this case. This was a VA loan. The mother was employed full-time when they applied. She is the applicant, and she's the primary mortgage holder, and her income was contributing to the payment of the mortgage in this very short marriage of 19 months. Of course, the mother was pregnant and had a child and stepped back from working for a period of time, but there's no indication that this case is anything like Cortez, where we have a very short-term marriage and the mother is the primary mortgage holder. Lastly, in Cortez, the court ruled that the expenses the husband paid toward the home were actually being paid as temporary alimony, so there was double counting. That is not present here. Here, the court actually explicitly states in paragraph 54 that the wife abandoned her claim for alimony. The court treated this request as part of the equitable distribution scheme because that's the way the parties presented it. And the court's fact findings on this are explicit again per 61075. There simply was no evidence that the wife was entitled to an unequal distribution in this case. So the court's decision to award those credits should not be disturbed by this court. The court did not abuse its discretion in making any of the rulings that the former wife challenges here today. For those reasons, this court should affirm the final judgment in all respects. Thank you.
All right, thank you very much. And we're back to Ms. Harris for the mother.
So if I could go back to your question, Judge Boatwright, about whether you could sua sponte reconsider. I think we're all in agreement that the court has that continuing authority to reconsider rulings that the court makes. I think what makes this ruling particularly problematic, in my opinion, is this is not a circumstance, for example, maybe on a suppression hearing where the judge has heard evidence and he's heard conflicting evidence or evidence that contradictory and made a determination, a factual determination. And then some point later on says, I've really been thinking about this. And I think I want to reconsider my factual determination on that. I think I may have been wrong. What we have here is a factual determination twice. And in the absence of any conflicting evidence, the court says, I'm going to reconsider that and put this back on the table. I think that's where the problem arises and where it becomes an abuse of discretion to do that. While courts may always sua sponte reconsider things, can they do that in the absence of any conflicting evidence or evidence to the contrary to the factual determination it previously made? And we know that's the case here because in the court's order, he says, while the husband hasn't presented any evidence to the contrary, meaning to the contrary to its prior ruling, I'm going to allow this to happen. And I think that takes it apart from a sua sponte reconsideration of a prior factual determination and brings this into a place where I think this court can find that the court abused its discretion in allowing that to happen.
And counsel, what's your best for that proposition? What's your best case on that point?
On the sua sponte reconsideration?
Yes, that it was an abuse of discretion here.
I'll be honest, Judge Edwards, I don't think I have a case or did I find a case that mirrors the factual circumstances here, where there's been a factual determination and in light of any contradictory evidence, the court sua sponte changes its mind. I didn't find any cases on that. And sometimes you run into factual situations that are so unique that, and I think that's what we have here. So I'm sorry, I can't provide you a case that I feel.
Counsel, isn't your argument that your client was going into the final hearing, relocation is not on the table, and now all of a sudden she has to spend all this money to litigate an issue that she didn't think she had to? It's almost like a detrimental reliance argument.
100%. And 100%, that's the position here. And where it becomes abusive discretion, in particularly because we have a social investigation that cannot be repeated by this particular investigator. They can't open the case up. Everybody spent $8,000. And the idea that these attorney's fees became inflated because of the relocation, we're talking about 6 months. Everybody up until May of 21 seemed to be in agreement that relocation was not at issue. Everyone, including the father, because we can see it through all as the case progressed, no one's bringing up relocation. And the idea that the father's attorney says at the hearing, it's not my job to correct the trial court's findings of fact when it's making, and it's precisely what he should have done long prior to that day. So when the court then comes in attorney's fees and says, well, this got this high, or most of this was spent on the relocation, when that's not really the case, there was no question of relocation up until May of 21. Nobody was operating from a place of we're disputing relocation. The court clearly found relocation was not applicable. And I want to kind of circle, I don't know how much time, I have no time left. So with that, I will rest on my brief. Thank you very much.
All right, thank you very much. Well argued, well briefed, and we will be in recess.
Thank you very much.
Good afternoon.